whole presentation. So how I cannot demonstrate the presentation due to some reason.
Oh God.
Do you need to share your screen?
Mm-hmm.
Karen,
Or I can see to everyone.
Is there an arrow under share screen next to share screen at all again, Karen?
No, it's not there again. I don't know what's going on.
Is it worth doing the host change?
Yeah, I can do that.
I swear when we started this course, Nick had a skinhead.
I swear when we started this course, you had a face.
Actually, I can.
Can you do it now, Natalia? I've just assigned you as host.
No.
No.
Okay, I think that I just can share it with you in the chat. Just a second.
Sorry, that's mine. Sorry, trying to work it out.
If the power,
Do you need a hand?
Or I'll
Natalia
try.
shared the file in the chat. Can you Nick, would you be able to
Okay, actually, I'll start and I'll just tell you all the information I was thinking of.
Yeah, sorry, go ahead.
Okay, so my name is Natalia Cherepanova. I'm with the Basilev's team. I've been working for Basilev's more than 10 years. So I'm licensed attorney in Russia, studied also in the United States. So I hope you'll understand my English with this strong Russian accent. Okay. Please feel free to ask questions or to give any comments you want, to stop me so we can interact like in Screenlife format interactively. So just a second, I'll open myself. Yeah. So Screenlife project and Screenlife format is the format whereby motion picture is framed inside the screen of a computer, handheld computer, tablet, smartphone or similar device, or within the frame of an app or other software program, as we know. This particular definition we use in most of our contracts, and this definition also reflects the entire idea of the project, and which poses a lot of questions in terms of legal work with such kind of projects. If you can open the presentation I've just shared with you on the second page, I'd like to show how do we approach all our Screenlife projects in terms of depiction of copyright protectable objects and integration of such objects in our movies. So the first thing that we need to undergo is the clearance procedure. And with all our projects, we do it in such a way. We create such kind of a table that reflects the basis for usage of all third-party protectable projects. In the first column, we indicate the time code. Then there is a link to original file and file name, and we have to be also careful. Sometimes the project can be already in public domain, but the file itself can be still protectable. Then we put the credit line, and then we put small legal notice. So what is the basis for us to use each object, each third-party object? So, for example, if an object is already in public domain or not. For example, we have already a contract. So in such case, we attach this contract to this table. So this one, this small table is from a real project, and all materials that I'm going to share with you are, let's say, real materials for real projects. Then you'll need this table for delivery, for successful delivery of each project to your client, whether it is a major studio, mini major, or independent studio. Then you need to so in most of the cases, especially if you work with majors and mini majors, no matter where, in the United States or in England or now even in Russia, they all ask for you to apply for errors and omissions policy. So errors and omissions is a form of liability insurance, which helps to protect professional advice, in our case, legal advice, which you obtain per each project again, from bearing the full cost of defending against a claim made by a third person who alleges her rights being infringed. And so in case there is a claim brought to court, but it's no worries, this situation is really rare. So in order to obtain these errors and omissions policy, you need first of all to provide an attorney, a licensed attorney in certain jurisdiction with this table that we have just discussed, that I showed you. And then I can not still share with you my screen, right? Or I'll try again.
I've shared mine. Can you see it, Natalia? I've got the document up now.
Yeah, perfect. Yeah. So I'll so in this case I'll send two more documents that I want you to be familiar with. Just a second. So first of all, and so let's start with this one. This is the legal opinion. Just a second. Could you please open it also?
I'll need to download it first, I think. It's allowing you to share now. Are you okay to share?
Oh yeah, perfect. Yes.
That's great, thank you.
Perfect. So here is the real legal opinion that we got for one of our projects, which the title Dead of Night. Probably you've heard of this project. So basically what we did, we gathered all the information about the project, about the legal aspects of the depiction of all 30 of all third-party copyright protectable objects, sent to the lawyer. He assessed our information, then he puts together his opinion on this. First of all, he describes the project itself, and in case we have like a series, digital series, he has to watch all the episodes of it, and he has to give his opinion with respect to each episode. Then he gives legal reasoning, all his findings, and as a result, he draws his conclusions. So there is no risk with respect to this particular project. And then we can go to the broker and ask for the errors and omissions policy. All such policies, so all terms are negotiable, of course, but most of them, first of all, they cover the entire universe. They will give you protection up to 5 years. So of course it has some kind of copay. For example, in my experience, I always manage to get policies with the 25,000 copay per each project. So it's a standard practice. And in case of a claim, you'll be protected up to $5 million US. So, and again, it is worldwide. So this is the procedure that we need to undergo with respect to every project. Such policy, so I can give you numbers with respect to the, like, let's say, legal opinion, so you can understand how, so what are the figures. And as far as I have understood, you're also thinking not only about legal aspects, also budgeting, so you can get an idea how much it would cost. So legal opinion is like per full-length movie, it's like $5,000 US, and then errors and omissions policy, it's like, roughly speaking, $8,000 US, up to 15. Of course, everything depends on the jurisdiction where you're going to use the rights to the picture and so on. There are a lot of variables, but roughly speaking, the figures are like this. So I'll try to go back to the presentation. If you have any questions, just stop me and I'll answer your questions. No? So shall I go? Okay. I guess that the most challenging
Sorry, Natalia, just did you try to share the Dead of Night letter there? Because all we're seeing is your desktop.
Yeah, now I return to my presentation. Can you see it?
Just your folders.
Okay. Can you see my presentation now?
No, it's back on your folders. I think you'd have to come out of it and then go back in, Natalia. So close that one down and then go into share screen again, and then that will give you a number of windows to choose from. Where you
yeah, I was there. Just a sec. Just a sec. I'm sorry. I know. I'm not always doing this myself.
Story of my life. Don't worry about it.
So I stopped, right?
Yeah, then go back into share screen again. And is it giving your desktop with all of the different windows that are open?
Yep.
It's gone back into your line of, into your legal aspects.
Yeah. Can you see it now?
Yeah, but we can't see your presentation.
You can't see it?
No, we can't see the actual PDF. We can just see that you've clicked on legal aspects of a Screenlife project. Have you opened that document?
Yes.
Yeah.
It may be that it's just selected a specific slide rather than the entire screen. That might be it.
And now?
No. Sorry, Natalia, could you, if you unshare again and then click share and then click entire desktop, that might work.
Okay.
Or change the slide.
Like your glasses, Nick.
Thank you. I got them today this morning.
I'm sorry for that.
We could get it back up in the chat again, you know, because I was looking at it in something else.
Karen can share it if you want. If you want to go back to the PowerPoint, Karen can do that.
Yeah.
I'm trying again, just in case. Can't you see it?
No, we just see your folders again.
Yeah, I done the same as Nick. Liam, I opened it via the.
You can, yeah, everybody can download it from the chat.
Yeah.
Okay, thanks. I'm sorry for that.
Okay, so we're on number slide 2 or slide 3 now.
Let's go to slide number 3, social media interfaces and logos.
Okay, just bear with me. Okay, slide 3.
4 it
Yeah.
is.
Social media interfaces and logos.
Yeah.
Mm-hmm. So I think that this aspect is the most challenging one in dealing with the Screenlife project. So the entire idea of a Screenlife is the fact that surfing internet and using of social media is an inevitable part of our life, and this idea is reflected in all jurisdictions, but of course to different level of, let's say, loyalty. And since Basilevs used to work with major studios, US major studios, we were trying to arrange the entire process of production in, as I find it, the most consistent way. So we were using US production companies, so we do not encounter any, let's say, cross-border jurisdictions in terms of approaching these issues in one jurisdiction in this way, in another jurisdiction another way. But the approach, more or less, when we are talking about common law countries like England or United States, the approach is more or less the same. So depiction of social media interfaces, web pages, falls into the category of exclusions from normal dealing with third-party protection, third-party objects. So if we have, so fair use is the doctrine that is used in the United States, and fair dealing is the doctrine that is used in these cases in England. And if we want to use such kind of objects like social media, web pages, etc., we need to meet this 4-pronged test, which basically reflects the idea that that using internet and all these social media pages is our life, is our day-to-day life, and we cannot live without it anymore. And first of all, so probably we need just to remember them, just like general ideas, general concepts, but we never got a case, like starting from 2014, when we got a bad legal opinion, or we didn't, we had a problem with social media, Facebook, Skype, WhatsApp, whatever. So everything is fine. The basic idea that we need to understand that using social media, etc., is fine with us. And if we want to remember those tests, so we can discuss them. So the first thing is that the purpose and character of the use, including whether such use is of commercial nature or non-commercial nature. So, for example, if your project is an educational project, or if you're going to use this film only for non-commercial purposes, so you're totally fine. If you also need to think if the object, not only interface, but any object was previously published. So you are not publishing it like for the first time, you're not releasing it. It's also important to understand. Then the most tricky test in fair use doctrine is the amount and sustainability of the portion used in our movies. So our Screenlife projects, they basically consist of interfaces, and they basically consist of surfing internet and various pages. But since it is really necessary to for us, for creators, to create such kind of movie using these pages, so we cannot say that the extent to what we use pages and to what we depict third-party objects is some kind of excessive or something. So, and the fourth prong is the effect of the use upon the potential market, which means that if we use, let's say, Facebook web page, it doesn't mean that we substitute the Facebook itself. We are not substituting the initial object. We are just creating something new based on this object that we integrate in our movie. And the doctrine that is used in England, so since these two countries fall into the category of common law jurisdiction, is the same, but there are only 2 necessary tests, while in the United States there are 4 tests. So if you have any questions, just let me know. No?
I have a question.
Mm-hmm.
So if you were a filmmaker was to mimic or create applications based on the same principles as social media accounts like Facebook or WhatsApp,
Mm-hmm.
there is no copyright jurisdiction there.
You mean like a parody, or what do you mean?
So if I was to create something that looked like a Facebook social media application for a film, there is no legal implication for me to do that.
You mean, what does it mean locked? Like, okay, if you are using, let's say, Facebook web page, and then you are creating your own social media page.
Yeah, that's based on the same principles, but it has a totally different name. It has a totally different look to it, color scheme.
If the interface is different, even though the mechanics is somehow the same, so the world of ideas is really unrestricted. You cannot be precluded from that. If the interface looks entirely different, or so, for example, in Russia we have this case. We have a social media that is so similar that Facebook. It has the same color of interface. It has almost the same mechanics. So the way messenger and pictures are placed on the interface, but it's really hard to prove that it was that the Facebook is somehow infringed. And no, if I understood you in correct way, yeah.
Right. Yeah.
Did I answer your question? Yeah.
Yeah, it sounds murky.
Okay.
But thank you.
So I was saying, Natalia, that for using, just take the example of Facebook, if we use Facebook, there's a potential for having to have a copyright clearance for it, depending on how much of it you use.
so if you use Facebook, it falls into the category. So if we are talking about the United States, it falls into the category of fair use doctrine, and this is like an exclusion from normal rules.
Okay.
You just need to get legal opinion that states that the way you've used that the way you have depicted it, the way you have used it and integrated into your movie totally falls into the category of fair use, and it meets all these four tests.
Okay, so in that case, in answer to Andrew's question, there would be no need for you to make up false face as a way of getting around copyright, because you would already be within fair use.
What do you mean by false face?
A parody version.
Parody version. No, it's another thing. Parody is like parody is one thing, and fair use is, let's say, fair use with respect to this social media. And I guess that you're gonna use in your work mostly such kind of pages, right? You're not, so it does not mean that you are making a parody to Facebook. You're not making a parody to Facebook. But you're just using Facebook in such a way that it's let's say transformative way. You're using the web page Facebook, and based on this usage, based on the web page Facebook, you create something new, totally new. You are not going to compete with Facebook and substitute their niche. You are doing totally different thing.
But Natalia, all these problems could be addressed at a conceptual or script phase, initially. So you have an idea for a concept for a film that utilizes interfaces that look like social media platforms. You can sort all that out at a concept or script phase and know you're going to run into potential legal issues ahead at that point.
Wait, you mean that you mean when you are using actual something existing, right?
Yeah, or if you're coming up with an idea for a script for a Screenlife film, you could identify where there could be legal issues ahead if you wanted to use certain interfaces or not.
Of course, yeah. It would be great if you could address those issues on the level of script, but in my experience, we have so many releases, and when we got to the point when we needed to undergo this procedure of clearance, we have never had an issue with usage of social media and all such type of pages. Never. That's why I'll share with you legal opinion also that we got for our first Screenlife release, which is where our attorney gives really good reasoning to every point of usage. So, and we have never had a problem with that. But of course, there is one aspect. In case you will be infringing like a brand name, if you're doing some like creating like a crash of a BMW car, this will be a problem. But other than that, no. So it would be great, of course, to address those issues from the very beginning when you have your script or screenplay just to show it to lawyers, and they will identify those spots. Yeah. So shall we move on to the next page? Fourth, fifth, yeah. So speaking of music compositions, if you are, so if you want to, and of course you would want at some stage integrate music into your Screenlife project, you need to, so you either commission the entire score to someone, or which is more often, you will license music from the owner of the rights. So in case you license the music, you will need to have a contract, and I'd like you to know about those, about the language that is really important for every synchronization license agreement that you might that you can be drafting, or you will be encountering. Yeah. So the most important things to get commercial license, if your project will be for commercial purposes, then to get right to advertise and to publicity, then to say that you are licensing the music for the entire universe, and that you're going to use the music for the perpetuity, for the entire period of protection of copyright, or speaking about recordings, anyways, for the entire protection of right. And one more important thing, it would be really great if in every project there is a wording that says that the licensor, the person who is providing you with the rights, waives his right to injunctive relief. This is the wording that every studio, major, mini major, independent studio, they are looking for in every contract, in every license agreement. So I think that's it. If you have any questions, just let me know.
Can you just explain a little bit about what injunctive relief means?
That a licensor may file a claim that precludes the copyright owner to the film to use the film itself. Not only the music, let's say, that you have incorporated in your that you have integrated in the movie, but the film itself.
Okay.
I was going to ask a question just about going back to social media pages.
Mm-hmm.
A lot of what we see with particularly like British series, they tend to have makeshift Facebooks, WhatsApps, etc. that Andrew and Mark were speaking about. I'm wondering about the kind of the unique features that certain apps will have. So, for example, I mean, it's not exclusive anymore, but things like Snapchat and Instagram have like the filters and like the lenses. Like augmented reality, like on iPhones, you have the Memojis, the Bitmojis. So I was just wondering, with things like that, those specific elements, is there copyright to any specific owner on that? And would you have to sort of, again, doctor it into something that's called something else? Or is that very much a case of that somebody's creative property, that whole idea of specific emojis, augmented realities, filters, etc.?
Yeah. Yeah, thanks for these questions. So I understand that such kind of masks and emojis, they are like an integrated part of every let's say web page or interface. But yeah, so in my experience, we always clear these rights, but sometimes at the production stage, we create our own emojis, which actually you cannot say which one is original sometimes, because they are so similar. But even if you use original font, you need to get a license. And when you are talking about when you're talking about, let's say, those masks that sometimes are used in the applications, I would say that this is a separate thing to think about, and I would license. I would try to get a license for them.
Even if it would be one, say for example, one of the very famous ones, I suppose, is the dog face emoji one, you know, the little dog ears and the dog mouth. So if I, say for example, wanted to use an emoji, not an emoji, sorry, I don't even, are they called lenses or filters? The language confuses me. But would I not be able to then go away and sort of just animate my own one, or would that still be somebody's sort of creative property in the first?
The tricky thing is that you can animate your own one. You can, because yeah, it's like it's something, if you have created it yourself, there will be features really original with you, not something that you have just copy pasted or something.
Yeah.
Yeah, but I would say that we have to look into each case every time. So in my experience, all producers, they are asking lawyers with respect to each object, which we have developed our approach in general to web pages, to social media. But speaking of such tiny things, we always try to deal with them on case-by-case basis.
Sure. Yeah, that makes sense. Thank you.
Natalia, can I ask about the hardware itself? So the types of mobile device or laptop or computer that might be, you know, featured. You know, obviously they have an operating system that is familiar.
Like Microsoft, or the approach is basically the same. So we are using Microsoft, we are using all pre-installed programs of Apple based on the idea that this is fair use.
Okay, thank you.
Yeah, and actually Apple is saying that we can create freely new objects, new products based on their objects, on their pre-integrated programs, which is iOS and all the programs that you find in Apple computer.
Thank you.
So I see. Okay, there is a chat.
So are there any other questions for Natalia?
I've got a question about the music composition, which is around a piece of music whereby the author the author's work may be out of copyright because they are died in 1930. Is the recording that was made before their death out of copyright, or is that still subject to a copyright license?
You what do you mean? So you wrote the music and you used lyrics on?
No, so a piece of music. I think a specific example, piece of music in which the author of the music has died more than 75 years ago, right? But the recording itself is also more than 75 years old. Is the recording also out of copyright?
Yes, right? Yes. You have to clear the recording. Yeah.
So even though the author's work is no longer in copyright.
Yes, but the recording is
Yeah, okay. The recording still is.
It's another type of protectable, let's say, object.
Right.
Yeah. You need to clear it. Yeah.
Okay.
Martin, sorry, just off the back of that, I don't know if anyone else is more used, but I can remember reading something recently about this, and for the life of me, I can't remember what piece of music it exactly was, but there was a case where it was something like you say, enough time has passed, the composer's died, and then, you know, normally it'd go into the public domain. But I think that recording, and if anyone else read it, please speak up because I can't remember what song it is. They renewed it so that it couldn't go into the public domain. I really wish I could remember who it was, but I remember that thinking, oh, that'd be nice to put in a thing now, free public domain, but now they extended it.
The recording, no. If the recording is modern, so you have to find the owner of the recording and and draft a contract. But the music, you can take the actual music and record it yourself. For example, there is another way.
Right.
You can, you can. Sometimes it's cheaper. Sometimes it's cheaper to get the music that is already in public domain and create the recording yourself.
So just off the back of that, sorry, Natalia, with for example, when you see a film within a film, a good example, a lot of horror films will often have Night of the Living Dead show because that's out of copyright and in the public domain. So how is that different to a recording specifically that may have passed the same amount of time as opposed to a film which people can freely use? Or is that, am I misunderstanding it?
So you mean if there is an old audiovisual recording which is incorporated somewhere and used somewhere?
Yeah, like
as opposed to music, but
yeah.
So I would say that these two objects are a bit different. And you mean this audiovisual recording was recorded like 75 years ago or even earlier?
So for example, I mean, I think in Halloween, the 1978 one, they use a thing from outer space. And I think one of the reasons why that's probably a bad example because the dates are a bit close together, but they're in the film Halloween, the characters watch the thing from another world that's what I mean. So Night of the Living Dead is often used by indie horror films because it's in the public domain, and I'm led to believe that they do that because they can use the characters watching that film because it's free, it's in the public domain.
So we are talking about a little bit different types of objects that are protected. When we are talking about public domain with respect to music, we are talking about author's rights. But those author's rights can be, they can be in a foundation that is still protectable. This is another system of protection and creation of economic value to the to the heritage of this author, and that's why what we always do, why we are creating these big tables that I have showed you in the beginning. We always do the research and find where is the file. For example, when we were working under the project iBible, so first version of that project consisted entirely of depiction of pictures of painters like 200 years ago. So they're more than 100 years ago in public domain, according to any system you can imagine. But the file and the picture itself is now in some museum, and we have museum rights. And then we start looking into this sphere. So we need to approach all these objects on case-by-case basis and see, probably, okay, there is an author that that released its object like more than 50 years ago, and it was created more than 75 years ago, and he died 75 years ago. But at the same time, the object is in someone's in a fund, in a foundation, or then if the project has only digital file, then you have to clear and you have to find the owner of this particular file, digital file.
Yeah.
So it would be reasonable to look into each case.
Case by case, yeah.
Yeah, case by case.
Thank you.
There is no other way. Yeah.
Any other questions? Anyone got anything else to share?
Yeah, one more thing, Natalia. So what would you say the most common mistake filmmakers for Screenlife movies make when it comes to this type of, legal situation?
It's not like a mistake. Sometimes people start gathering all the work really at the later than it is supposed to be. So if you approach the delivery point, you need a lot of information, because all Screenlife projects, they consist of so many protectable objects of third parties. So you just can be in real stress, and just you won't just have time for research to find every project you need. And it's really good to start, as you earlier said, to start with the assessment of your screenplay with respect to probably your, let's say, infringing in terms of reputation of a brand, which is one really important point to address from the very beginning, and from the very beginning to start looking into the actual project that you are using. So you can have like a manager, assistant who can make a research and find probably there is something that you're trying to integrate, but probably it costs a lot, or you cannot. Okay, if you cannot find product owner of, let's say, 1, 2, 3 objects of the entire movie, it's okay. It can be covered by the legal opinion. There are such cases, but you have to show that you. So let's say you were acting in good faith. You were trying to find the product owner, because if you are looking and if you're searching for materials online, it's actually really often when you find something interesting, like a picture or something like a painting, and you cannot find the author and you cannot find the owner. It's really often, but you have to show that you were trying to do that in good faith, and then it will be covered by the legal opinion and errors and omissions insurance. But of course, if it is not, let's say, out of 50 objects, 45, of course not.
Thank you.
Yeah.
Okay, so is that all the questions done now?
Just ask a question about copyrighting your own material. When you make the film or you write the script, what legal protections are there?
You mean if you created the script, right?
Yes.
So if you created the script and the script is so the movie is based on your script, you're supposed to have a contract with the studio. You have to you will be accorded credit, so the entire variety of rights. Then you can negotiate how you can approach the subsequent production based on your script. You mean like what rights do you have, like a script right? You're entitled to compensation, to the name. You have to you can regulate the way your likeness is used in association with the publicity of the movie. There are a whole variety of rights you have.
They would kick in at the point of signing the contract with the company.
So if you have submitted your script to the company, you can negotiate. So the main idea is that you have actual contract with the studio, and then you can provide for any type of terms. So, for example, when we were drafting agreements with respect to the competition, so competition says that competition provides you the opportunity to get into the industry, and here we have to wait. Yeah, so let's say whose input is bigger. So this is one part of an issue. If you're already well known, you can negotiate another type of contract. So it depends. It depends. Of course, the basic rights you have is the right to your name, the right to discuss what's going to be with the subsequent production, compensation, and so on.
Okay, we've got a question here from Daniel about the use of Apple products. Daniel, do you want to ask a question? Karen, do you want to take the screen down now?
I was watching a interview with Ryan Johnson, the director, a while back, and he was talking about how in Knives Out he wasn't allowed to get the sign off from Apple to use iPhones for the villain of the movie because they don't allow the negative use of their iPhones, I guess. Is that a known issue?
You mean negative use? So there was some kind of infringement of their reputation, of the brand.
Yeah, I think that's what Apple tried to say.
Yeah,
apparently, you couldn't get used to it.
Of course, this is the main issue that can arise. that you have to address at the very beginning when you are writing the script, like what will be the nature you depict the brand. If this is the nature that in any case won't be deemed by the brand owner as defamatory or something, it's okay. But it's always, you know, it's always really a thing that where lawyers always saying, okay, we will find that out in the court. But yeah, you have to address it. You have to address this issue from the very beginning. But sometimes you understand that there is no potential to such kind of claims.
Thank you.
Okay, so is that everybody's questions now? I'm just really conscious that we've kept Natalia for 10 minutes more than we said, and I really appreciate you coming on. It was only yesterday we had the conversation, wasn't it? I thought we'd booked it ages ago, but thank you so much for coming over and sharing that with us.
Thank you. Thank you. If you have any questions, just let me know. I provided my contact information, so you can email. I'll try to answer all questions.
Thank you so much, Natalia.
Thank you.
Thank you, Natalia.
Thank you. Bye.
Bye.
Bye-bye.
Bye. Martin, do you wanna talk about the next step, and are we gonna have a break?
I was just trying to sing Natalia Cherepanova to the tune of Champagne Supernova. I won't do it while she's on. I think that's
clear the rights.
Clear the rights first. All right, okay, fair enough. I'll go and speak to the Gallicers about it. Right, excellent. So what I think we'll do, we'll have a break for a moment, then we'll come back, and we've got a couple of big ticket items to discuss. One being invoices and claims, etc. I want to offer a masterclass on how to write an invoice, which I think you find very useful. And then we want to talk about the proofs of concepts that we've got so far and what we're going to do in the next 7 days up until the 29th. And I think that when we come back, we've probably got about